NACDL is the association of the nation's criminal defense bar.
But what I'm going to talk about is cross-examining cops in confession cases. So we have had lots of speakers talk about how police interrogate people. You've seen lots of real confession tapes, so I'm not going to repeat that. I'm not going to talk about experts. I'm strictly going to talk about the actual cross-examination and how we're going to educate our jurors that police interrogation isn't a search for truth, but it's a quest for a confession, because the police come into the courtroom ostensibly to just relate what our client said, but they're doing a lot more than that. They're trying to convince these jurors that they are human lie detectors, that they know what the truth is, and that they alone were able to get the truth out of our clients. And that's part of their whole messaging. They're really portraying themselves as an expert witness. So when we are doing these cases, I'm just going to talk a teeny bit about the prep, and then I'm going to get right into how you're going to do your cross, okay? So I think we all know that you have to really learn about interrogation techniques. The reason I started to learn about this, when I was a brand new lawyer, right out of law school, I really didn't know anything about false confessions. I was in the same place as most lawyers. Your client confessed, you thought they were guilty. So let me ask this of the people here, who really loves doing confession cases? Do any of you just like love it? Okay, wait, I saw one hand right away. I see two. I see five. Okay, so most of you are saying, oh my God, it's a confession, it's going to be a tough case, I think I'm going to lose. And according to what we've been told by the experts, we mostly do lose, that confessions are very persuasive. But one of the things I have come to believe is it doesn't have to be that way. We can convince jurors that confessions are false and that our clients are innocent. One of the most interesting things I saw was our very first speaker, and what she talked about was the difference between just hearing the evidence and having either an expert or a closing argument. And there was virtually no significant statistical difference between an expert witness testifying when the jurors, or the subjects for the experiment rather, saw that, or reading a well put together, really well done defense closing argument. And I agree with that. I think it's great if you can get an expert. It's great if your client has the money. It's great if your public defender office has the funds. It's great if the expert is available. It's great if the expert says this is a good case for me. But that's not always the situation. You can win these cases without an expert. And in order to have a great closing argument, you have to have a great cross-examination of the cops who took the confession. So while that hasn't been studied, that is what forms the foundation of your closing argument. So you're going to start by educating yourself. Criminal interrogations and confessions. All right, how many of you have heard of the book before this morning when somebody else showed a slide of it? So how many of you have read the Moran decision since you went to law school? I know you've cited it in your motions, but when the Miranda decision talks about how coercive police interrogation is, this is what they call the manual in the decision. It was just in an earlier edition, and the bones of it have not changed. The core of it is exactly the same. It pays some lip service to false confessions, but the actual retraining doesn't really do much of that. And in fact, their organization has developed so much for police interrogators. Wherever you happen to be from, they are training people near you. If you go on their website, you will discover that they have about 2 training sessions per week in some part of the country, and they have all these materials of particular themes that they're going to use, and I don't need to explain what those are because you've been told that, particular themes for different kinds of cases. And I have listened to interrogations, I don't know how many, but I've seen them, listened to them, read them from all over the country. So as you are preparing to cross-examine the cop in your case, And as you are listening to and reading the transcript of the interrogation, what I recommend you do to prepare your cross is to make 3 lists. You want to go through and make 3 separate lists. Number 1, every coercive technique that the police officers used or the agents used when they interrogated your client. And I think we all know that there's these different styles. There's interrogations that are soft, and there's some that are more confrontational. So whether it's soft, a soft tone like the cops in the Deja case, or more confrontational like the other tapes that Steve and Laura showed us, you want to make that list. Number 2, you want to really feel and understand what in the confession is actually true and conforms with the reality of the case facts, and the world as we know it, and what is blatantly false. Because as Steve and Laura said, a person who doesn't really know or didn't commit or wasn't at the crime scene doesn't really know all of the details, which leads you to number 3, which is you've really got to make this list of contamination, which they talked about. Because one of the things that we have been told this morning, and it's really so true, is jurors don't really care how much coerciveness there was in the interrogation if they think it's true, okay? They're not really going to care that the police lied to your client or implied or explicitly told them that they were going to get off easier if they really think that your client, like, sexually abused a child or murdered somebody or shot somebody. They don't really care about that. That doesn't mean it's not important in your cross. It's super important in your cross. And the reason it's super important is you have to show the means to which they got the false confession. But you've got to show the confession is actually false and have that as part of your theory of the case. So in your prep, I suggest that you visit the scene of the crime, or that you at least are really familiar with what the dimensions are from looking at the videotape. You really know what the place looked like, so you can paint a good word picture in your cross-exam. I suggest that you research your police officer. Look at the training records, which I'll talk about in a minute, but you want to know about their career history and trajectory, about their record of misconduct and discipline inside the police department. You may want to look at transcripts from other cases. You want to look at civil suits that they've been involved in. These have proven to be really critical in some of the cases that I've worked on or am familiar that other people have worked on. For example, there was a Milwaukee police detective who had an interrogation technique of, as they talked about, bringing the big files in, you know, we have this, we have that, we have the other. So what this particular guy would do is he would bring these files in and he'd say, look, I'm going to tell you about this defendant case I worked on. Defendant number 1, he confessed immediately, he testified. He's doing 2 years. Defendant number 2, he didn't testify, but he did eventually give a confession. He's doing 10 years. Defendant number 3, he went to trial. He's doing life. And he would like bring this in. And so first of all, it took us a long time to track down the real case so we could figure out what the hell he was talking about. But more importantly, talked to other criminal defense lawyers who had done hearings with the detective and got a transcript of their motion to suppress. So that way we knew every single answer he was going to give to all the questions before we did the motion to suppress. This was before we had recorded interrogation. And these motions for us back then were much more like depositions that we would use for pretrial preparation. So you can't get enough of this stuff because you may find a nugget in there. You may find that an officer was disciplined for some kind of lie, and if that's in your case, you're obviously going to cross-examine on it. You also want to really, really get to know these tapes. So you have got to know exactly what you're going to play, and you've got to, you know, we all know that cross-examination comes in chapters, and that's what I'm about to start covering, what the chapters will be. But you've got to know what your chapters are going to be and exactly where in the tape you're going to play it, because you want to have a smooth presentation in the courtroom. You want to be ready to play it, you don't want to be futzing around, and you want to make a decision. Like, generally speaking, the prosecutor is going to take a part of that tape where the confession exists, and they're going to play whatever it is, you know, an hour or 20 minutes or whatever particular segment is going to be beneficial. We're probably going to want to use different portions of the tape at different times after the police, who invariably, they don't listen to their recordings before they come to court. They really don't. I've never seen them listen to their recordings. They're usually confused about what on it. Their reconstructive memory has changed in their minds how things went, and they can't remember. So by being really well prepared and having the timelines and exactly with the tape and transcripts for the jury, you know, we can be so much more prepared and get the better of them after they've spewed out all this bullshit on direct. So the next thing that I cannot emphasize enough is how important it is to get their training materials. I cannot imagine doing a good cross-examination of a police officer in a confession case, or many other things for that matter, without seeing how they were trained in how to interrogate people. So depending on where you practice, that can vary. In Milwaukee, where I have done most of my law practice, they don't send very many people out to read because it's really freaking expensive. It's like $1,000 to go for the 3 days. And I did think for me it was very money well spent, and I actually went to 4. I went to their advanced day. But most of the time in big cities, they are not as likely to contract to bring some read in or send all their people out because it's too much freaking money. What they do is they send out some people to go to read, to get trained, and then they have them come back, reproduce some of those training materials inside the department, and use that to teach the police officers who are going to do the interrogations. If you're from a smaller place, like when I did a trial in Appleton, Wisconsin, they actually sent people out to the Reed School. So I wanted to get their training records to see exactly when were they trained in interrogation, who trained them, how much longer, have they had subsequent classes like at their annual or semi-annual in-service. So you want to know all of that stuff. And then I want to actually get my hands, even more important, on the actual training materials that the police detectives had in their possession before they interrogated my client in this particular interrogation. I also want to get a list of their policies and procedures or anything they have in writing at that law enforcement department about interrogation in case they didn't follow any of those procedures. Generally speaking, that hasn't really done much for me, but you never know what you're going to get. So what you're seeing are written materials from Reed and Associates that you can buy on their website. This is probably not what you're going to get. I'm going to show you later some pages of what I think you're more likely to get when you're getting training materials. When you do your cross-examination, and you all know this, but it always bears repeating, only cross-examine to support your theory of the case. So if your theory of the case is not that this is a false confession or there's something in it that you like, then you're not going to cross on it in the same way just because it's fun. And I really hope that those of you who dread confession cases and trying them are going to walk away excited after being here for a day, because I think they're actually fun to try, okay? You may not think they're fun to try, but do you like pleading people guilty? Do you have super fun at sentencings? Or did you become a lawyer so you could cross-examine a cop? I suspect that's why all of you are here. So, what could be more fun than putting them on the hot seat when they think they are so tough that they can come in and spew all this bullshit, and then you're going to do a really top-notch cross on them. That's what I call having fun as a criminal defense lawyer, and hopefully we'll get to the ultimate thing, right? Don't they say it's better than sex, not guilty verdicts? Right? You know what? They lied. That's a bunch of bullshit. Sex is way better. Okay. So we want to get our words into the case, right? We want the jury to know it's an interrogation, not an interview. Because when we think of interview, this is exactly what we think of, okay? There is our well-dressed, smiling job application in the traditional blue suit and dark tie, and he just looks fantastic. And I mean, one look at that face, you totally want to hire this guy. It's a really pleasant exchange. And the prosecutor is going to do in their direct, well, when you interviewed Mr. Defendant, blah, 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 and when you did your interview, bullshit, this was not an interview in the slightest. This was an interrogation, and that's an emotionally loaded word that has a different meaning. It really looks a lot more like this. in most people's minds. And we want to get out the real word, and we want to bring that out in our cross. And they, armed with their training materials, they are trained in the difference between an interview and an interrogation. That's a term of art in law enforcement lingo, and they'll kick into it because they know that you have the goods. So let's start talking about our actual chapters for cross. Number one, you really need to establish your detective's familiarity with the crime scene and the case. This is like super important because you're going to be arguing at a later time that they contaminated this interrogation, so you have to show that they're familiar. So you need to chart out with the detective exactly what role did they play in the entire case. Were they the cop at the scene? Did they talk to the victim if the victim is alive? Did they gather evidence? Were they a supervisor? Or did they learn about it at a shift briefing? If they learned about it at a shift briefing and then were assigned to the interrogation, you want to learn more what those look like so you can paint a word picture, right? Try to see if you can generally educate yourself about what goes on in these and learn the most that you can. I'm going to tell you how I learned a lot about how cops operate, by chatting it up in the hallway. I'm like very friendly with police detectives in the hallway while I'm waiting for court. We talk about all kinds of shit. We talk about our kids, we talk about our vacations, we talk about their supervisors, we talk about the prosecutors they don't like. You know, I think doing that goes a long, long way because you will get nuggets of what to do. So honestly, being a friendly person in the hallway is super important, and it's really paid off for me. So this is something that you want to know about, but even before you do that, you probably want to ask them about their general training and the fact that they were trained in interrogation. So I want to talk about that. I have never, ever cross-examined a police officer who has told me that they have used their training in an interrogation. Not only have I never done it, I have never talked to another criminal defense lawyer who has told me that when they were doing one of these cases where they're really fighting tooth and nail about the confession, that the cop has said to them, I used my interrogation training. From sea to shining sea in America, they all freaking deny it, which says to me they know something's wrong. So I like to cross-examine them about training, but I don't go right to interrogation training. I just bury that in all kinds of stuff, using their gun, learning how to collect crime scene evidence, how to talk to witnesses, how to conduct a photo array, how to make sure evidence doesn't get contaminated, how to interrogate suspects, how to do follow-up investigation, how to write a report. It's just buried there in the middle. And so what do I like to go to first? I like to go to the gun. I really like the gun as the first thing, and that's the one I spend the most time on because you can cross-examine a cop something like this. You went to the police academy, and at the police academy you learned how to use the weapon they gave you. You learned how it functions mechanically. You worked on target practice with it. You took shoot, don't shoot type of simulation so you could learn the appropriate use. And this training was important. It was very important and valuable to you as a law enforcement officer. And you use this training. And you should get a string of yeses, right? And then you can go through all the other stuff and not spend as much time on it, but you want to continuously say your training's valuable, you use it, blah, 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 and you just slip the interrogation right in there. Sounds good, right? So let me tell you about what happened with this trial I had. Got the cop on. He was retrained. As you can see, there's an exhibit sticker on here. It's from that case. And that's the actual book that they use in their trainings, and that's what the training materials are likely to look at. I started asking him about his gun. You know what the asshole says to me? He knows way better how to use it than the training at the academy. He didn't pay any attention to it because he's been in the military. He does it, and he can train way better than all these people. And I'm like, oh man, this is going to be a long freaking day. Because you just want to fight with me, and I am doing the most benign thing, and I'm going to tell you the jurors hated this guy. And he was critical to their case, and they hated him. So if they want to give you a fight about a gun, fuck it. Have a fight about a gun. Okay, I hope I'm okay with saying the F word in front of you guys. every now and then, I'm just telling you, it slips out by accident. I don't mean to do it that much in the CLE context. But so he wanted to have a fight, and we did, right from the jump. Okay? So that's fine. And then after that, and after you've established the training and their familiarity with the case, I think it's really good to talk about case weaknesses. And part of what I do when I challenge the admissibility of interrogation, so we're talking about trial here, so we're of course assuming that you lost the motion to suppress. A lot of the chapters that I'm talking about you can also use in suppression motions. But I want to tell you guys that when I file a motion to suppress a confession, I also challenge probable cause to arrest my client. Not because I think I'm going to win that, because we know probable cause is like a sliver on the map of what they need to do, no matter what the law books say, right? Judges always find probable cause to an arrest. But I like to raise probable cause to arrest, and the reason I do it is because whenever I'm thinking about these cases, I make a list of, if this was the perfect case, this is what the cops would have, right? They would have DNA. Not just any DNA, no mixture, no contamination, big sample, no, little teeny samples or low copy, so they would have that. And, they'd have really good fingerprints, and they would recover the gun, and they would say that the bullet that came from the gun was a match. Let's say it's a homicide case. And they would have the world's most credible witnesses. I mean, they would have the teachers who protected those children at Sandy Hook on the stand, right? Really a good emotional pitch. And that eyewitness identification, I mean, it would be perfect, down to describing the gray hairs on my client's head if he had any. I mean, they would have photographs, they would have a video of the crime. I mean, I just think of like everything under the sun. And then you look at this case. So what do they really have in this case? They have an eyewitness who was off by 6 inches on my client's height. They have the confession, of course, which they've recorded. They don't have any fingerprints. They don't have any DNA. They haven't recovered the gun. And their witness is Mr. Snitch, who's got 6 priors, which led them to go arrest my client. They don't have the school teacher from Sandy Hook. So whatever it is, I make a list, and I challenge this probable cause, and at the motion hearing, I cross-examine them, so I have the transcript all set for trial about everything they did and didn't have, so that I've got a list to do this, and I know exactly what they're going to say before it comes into trial. And then at trial, I'm going to cross-examine them about how weak their case was. And if I say you had a weak case, they're going to say they didn't, so I don't ask them, you had a weak case. I could save that for closing, okay? But what I want to get down to with them, basically, is that they had an opinion coming in that the client was guilty. Now, technically, they're not supposed to say that. And by the way, this is a super dangerous question. If I have had anything excluded, not just a Fourth Amendment motion, but motion in limine where or there's client's got a big prior record and they're not going to find out about it, I never ask this question, because then you have just opened the door and you don't want to go there. So this is if everything they have and know is coming in. So this is a rarely used question, but it may be appropriate, so I wanted to call your attention. They will somehow get out that they had that opinion anyways at a certain point, whether it's stated directly or it's implied. That's going to be part of the deal here. So I don't see anything wrong with bringing it out in the open as long as I'm not opening the door to other suppressed evidence. But what I do want to say is that their purpose was to get a confession, and I want to then start again bringing out the difference between an interview and interrogation. So let's talk about the fact that their purpose was to get a confession and how that's going to be. So if Jim Tradin can just come up here and play detective for me for 1 minute. We're not using that before. Playing a detective? Yeah. So, Jim Tradin is fantastic. I think I told you before, I've actually had him as a witness in one of my cases, and in fact, it's the very same case that the cop wanted to argue about the gun with me. So, but what I want to say, so we're just going to use the Brendan Dassey facts because it's common point of reference for all of you. Don't worry, I'm not going to torture you and make you see those tapes again. But just to think about this being it, and he's the detective, and I would say now, when you interrogated Mr. Dassey, your purpose was to get a confession.
Well, it wasn't an interrogation. I was interviewing him. And no, I was just trying to get to the truth.
Okay, so I didn't know what he was going to say, but assuming he says this interview and interrogation thing, I'm going to show him his training materials, and I'm going to, or at some point, I'm going to prove that it was an interrogation. I'm not going to do that right now because that's not really the purpose of what I'm doing. So skipping aside, what he basically said is his purpose was to get the truth, right? So they're all going to say that. They're all going to say that, and if they have a chance, they're going to throw in training and experience. But his purpose was to get the truth. So where are we going with that, right? So in other words, the classic cross is where you ask a question you know the answer to, and the witness is supposed to say yes, right? That's how you've all been taught to cross-examine. This isn't that classic cross. I am trying to provoke a fight here. This is a fight I want to have. So the truth couldn't be that Brendan Dassey was at home at the time Therese Halbach was murdered.
Well, no, of course not.
The truth couldn't be he was in his living room playing video games.
No.
And the truth couldn't be that he went over to Steve Avery's and just saw absolutely nothing in that bonfire.
Absolutely not. It wasn't.
So you had that opinion, so your purpose was to get a confession.
No, but that's what we found out during our investigation.
Well, let me ask about this, okay? You weren't at the scene.
Well, no.
You don't have a video of what actually happened to Teresa Halbach.
No.
You didn't have any physical evidence that Brendan was there.
No, we couldn't find any.
Right. There was no DNA, right?
Yeah.
No
right.
fingerprints.
Yeah.
No video recording of him being there.
Well, no, you wouldn't expect that.
There was no video recording of him being there.
No, there wasn't.
So you aren't a personal witness, and your investigation, as you like to call it, about him being there really consisted solely of what you were able to get him to tell you.
Well, yes, he admitted to being there.
I understand that. But nothing leading up to this investigation at this point, you had no evidence that he had been there.
Well, no.
Thank you. All right, so this is what you're going to do. So you're going to provoke the fight, and they're going to fight with you about it. They're going to say it's the truth, but you know what? Who cares? What you do, okay, so this is Brendan's real story. So Brendan's real story in the real case is exactly what we said. I mean, this is what he told the police at first, that he was at home during this time and that he was actually playing video games, and he went over to Steve Avery's later and he didn't see anything, and he went over for a bonfire and he didn't see anything amiss. So that was his story. So you're going to take your client's story or part of your theory, you're going to trilogize it, turn it into 3 or multiples of 3 because that's effective, and you're going to ask the cop, and they will always say it couldn't be that because they believe it couldn't be that. And then you, of course, you want to point out, like, they didn't have shit, right? So this is going to vary, but they weren't at the scene, they didn't have a video, whether they had physical or evidence or not. That's all going to depend on your theory of the case. So you're going to fill this in with the actual stuff from your theory. And then you're going to, because we're talking about getting a confession and that being a purpose, remember, we asked them all this stuff about their training materials. Okay, so it's going to go something like, you said earlier you'd been trained in interrogation, right?
Yes, I have.
And you testified that your training has been helpful to you in police work.
Yes, very much.
When you went to training, you were given training materials.
I believe so, yes.
Okay, so I'm showing you it's been marked as exhibit number 17, and it's going to be this, right? So this is the copy from the actual Milwaukee Police Department training materials that they hand out about interrogating homicide suspects, and the subtitle is called Get That Confession. So these are the training materials that you were given, correct?
They look familiar, yes.
And in fact, it was the Get That Confession.
Well, yeah, but it means the confession to the truth. That's what we're after, the truth.
Your purpose in talking to Mr. Dassey, consistent with your training, was to go in there and get a confession.
But yeah, but that's, you know, to the ultimate truth. That's what we got.
Maybe my question wasn't clear enough. I apologize if it wasn't. Your purpose was consistent with your training to go in there and get a confession,
Well,
right?
based on what that says, yes.
So your answer is yes.
Yes.
Okay. So, you know, we can go there with these guys. I want to tell you, like, I was told a number of years ago that the Milwaukee Police Department had looked up one of my outlines on interrogation, that they found it on the web, and they're now using it as training materials at the Milwaukee Police Department. And I'm like, okay, people, but this isn't going to help you. First of all, I didn't do a video of the cross with every single question. And second of all, we can't lose this if we do it right, okay? It doesn't really matter how much fucking studying they do, you know, and they can't start saying, well, in your last trial you asked me that, and you can eliminate that bullshit out. So, I'm not going to keep questioning him right now. There'll be a little section in the future. If you want to stay up here, it might be easier for you. But so here's some other chapters for cross, okay? We want to paint a word picture of the interrogation room. It's not a friendly place. Now, these days we have these recordings, but you know, some of you may, heavens help you, be in a place where it's not recorded, or the pictures they show aren't very good. So you want to really do the whole word picture, you know. You should go and measure it. You can tape it out on the floor with some masking tape to show how small. You can extend your arms. Maybe it'll take up the whole space, especially if you're taller than me and you have a bigger arm span. You know, you can play with this and play with the space and how you want to act, because we all know trial law has this element of theatricality to it, and we want to do the best that we can with that. So this is all really important stuff. We can use the clips. You know, you can rebuild one if you got a big budget. I mean, you can do all that. But even more important than the physical layout of the interrogation room, you really want to do time if it's been a really long interrogation. So just take a watch or a cell phone, you know, that counts out the seconds, give it to the detective, show it first to the DA, have it on the, you know, so that the DA is in on it with you and nobody can say you were unfair, and you have him start and stop like a minute. And, you know, detective, when this starts, I want you to tell me when a minute has gone by. I mean, it's a freaking minute, right? It seems so long in court. And then, you know, there were 2,344 more of these during your interrogation. So that is another way that you can express time, besides you talked to him 3 times and you spent a total of 17 hours interrogating him. So you can make it more lively for people and more meaningful through doing that. You can also talk about the fact that they have specialized legal knowledge when they are developing their themes, which you're going to get to. For example, you know, they know what the elements of various crimes are and what they know, and they also have the ability to really shape interrogation based on that. So I think it's good to educate the jurors about it. You can point out that they use leading questions if that's what you have on your tape recording. That they did that, but they were the sole determiners of whether it was a proper leading question. It wasn't like in court where you have a judge and opposing counsel who can object if something's an unfair leading question. Make sure you do that, because you're using leading questions and you don't want the jurors to think that you're unfair. You want to talk about opportunities that they could have had for coercive conduct if they really existed, like the parts that were off tape, or, you know, you have to see what's in your particular interrogation. Was it soft? Was it more coerced? Would your client tell you happened off tape, et cetera, et cetera? So this may or may not be applicable, right? And certainly, you want to talk about your client's vulnerabilities when they have them, right? That the police officers either didn't know about it, or ignored it, or exploited it. So for example, in one of the cases I did, it didn't go to trial because the confession was suppressed. My client was a brittle diabetic. And as a brittle diabetic, they weren't giving him his insulin. And when they transferred him over from the police administration building where they'd interrogated him for 3 days without medication, and then took him over to the real jail, where the first thing that happens is you have medical intake and they take your blood sugar, and his blood sugar was through the freaking roof. So we called an expert witness in that particular case, a neurologist, to talk about the effects of high blood sugar on the functioning of your brain and your ability to think and communicate clearly. So that's a particular thing, but this is why you've got to have this really good social history and medical history and know when your client ate and their medications and all this kind of stuff. So talking about, you know, stupidity, let me tell you something. I was cross-examining one of the cops, and I said to them during the motion hearing, you know, he said he was a diabetic and he wanted medication. They never usually have medications in these police departments. They have to take them out. You know, they're not a medical facility the way that like a county jail might be, and they have to take them out to the hospital. They don't want to do that because that interrupts the flow of interrogation, could give a person a chance to communicate with the outside world, et cetera, et cetera. So I said that, and he said, yeah, I knew he was a diabetic, so I offered him a candy bar. I'm like, how freaking dumb can you be, okay? We had a diabetic on the jury, so, not on the jury, I'm sorry. That wasn't a jury trial, but we had the judge who knew something about it, and I mean, it's just like some crazy stuff. So if you have that, if you have a Brendan Dassey, if you have a psychologist, clinical psychologist, you're going to go through all this stuff. You know, you don't have a degree, you don't have psychology, you know, maybe you took one college class, but you don't really know jack about this. So you're going to cross-examine about that, right? And then, of course, you're going to go through everything they did in the interrogation process, and you're going to start naming it. So before it was talked about how they interrupt the denials. You want to count that up in your tape, how many times they did it, you know, and it's often like in the 40s and 50s if you have a long interrogation. So they're not going to remember that. Get the whole thing marked up and numbered and give it to them. Oh, detective, would you like some time to review this? Of course, you know, you'd be super nice. You know, you're trying to be really patient. Let them be the ones who are getting pissy on the stand, right? So you want to do that. You want to go through the bait questions. And I've had them say, well, counsel, what's a bait question? Like you don't know, you idiot. Okay, well, do I need to explain it to you? I will, or I can impeach you with your training records. You want to really spend time on the themes they develop, because that is, in fact, the heart and soul of the Reid technique. And all the stuff you heard about, like, I've had this happen, like it's a shooting, the detective will talk about the trouble they got in, how they once stole a motorcycle, or the guy in their neighborhood who confessed and only did a few years after killing somebody because after all it wasn't really intentional, and look at him, he's married, has 5 children, and owns the corner bodega now. So, you know, all kinds of bullshit. I mean, honest to God, my client's mother died of cancer, that cop's mother died of cancer, and lo and behold, it was the same kind of cancer. I mean, you see so much bullshit that happens in these whole theme developments. And then, of course, there's the alternative question, and it's not, will you marry me? It's, are you guilty or are you guilty? And that happens in some interrogations, but it doesn't happen in every single which one. You'll have to look at how they popped the question, so to speak, and got the admission, which, of course, is not the confession. It's just an admission. It's all about the post-interrogation negative. So you want to really highlight the coercion that's involved, and then you want to impeach them with their training records. So what do I particularly mean about that? Okay, so here's the actual training materials that were handed out that were part of this exhibit. You saw the cover. It's probably really difficult to read this from where you are, but this is from Reid, right? And this is what they say in their training materials. Do not make statements which could be perceived as a promise of leniency. 1, I want to help you out on this thing. I mean, if I've seen a cop say they want to help my client who's being interrogated, I've seen that like 150 times, right? It'd be better if you told me it would happen. If you were drunk when this happened, I can explain it to the judge, who will probably give you a break. So they tell them not to do this in the training materials, and then you've got it on the tape. So this is really, really helpful, right? Or here is some other ones that are pretty juicy. To not ask improper alternative questions. Do you want to cooperate with me and tell me what happened, or would you like to spend the next 5 to 7 behind bars? Or here's one that I've actually heard. Do you want to be charged with first-degree murder, which will mean life in prison, or was this just manslaughter? So they are asking these questions, and you've got this great opportunity to impeach them with this training material. So, you know, here you've had this cop who's maybe at this point said that they haven't used their training because they're smarter or they're better, or what they usually say is, I learned it on the job. That's almost universally what they say. You know, I went to other interrogations, more experienced detectives. I learned it on the job. It's a free-flowing conversation. It's not really scripted. It's not like what they teach. They're going to say this. So you've got great stuff, because in your closing argument, when you do this cross, what do you say to your jurors? You say, ladies and gentlemen of the jury, the Milwaukee Police Department invests thousands of dollars in training their law enforcement officers. They have this big training facility on the northwest side of our city. They have police officers who are full-time trainers. They've come up through the ranks. This is the job. They spend thousands of dollars to send these people out to Reed and Associates so that they can learn the right way of doing this. And what did Mr. Detective here say? He said he knew better. He said it didn't matter to follow their training. Here they have all of this so that they won't get false confessions and he thinks he knows better than the people who've studied this and done this for who knows how long. So you can actually use these training materials and use this Reed stuff to your advantage. You have to decide your theory of the case. Are you attacking it because it gets a false confession, or did they not follow it and therefore do things that are not supposed to be done, and they're taught this way so that you don't get a false confession? So your theory is primary, and you have to know if you're going to use this or not, but this is like really good stuff. I just love these training materials. You know, I just can't even see, and you know, they can't change this shit, right? They can't change it. So I'm going to then contrast this theme development stage, right? So that theme development that you've heard about, it's all about minimization. It's all about putting the empathetic cop on the same foot with your client who's had these same problems, who can help him, who can let them know that they're not going to be that much trouble, but bam, an admission is not a confession. They have to construct a post-admission narrative because a yes, I did it isn't going to cut it. And this is where you've really got to know what's going on with contamination in your case. So what you've got to do, remember those lists we talked about that you make up about what's going on? You have to really know where each and every fact in your interrogation transcript that came out of your client's mouth, where did it come from, okay? Were they familiar with the neighborhood where the crime was? Did they see, was it high profile? Did they see it on TV? Or as in one of my cases, did the parents of the victim go hang up posters of what their deceased son looked like and where the crime happened and when it happened? Did the police feed them facts during the interrogation like they did with Brendan Dassey? So you've got to be able to account for each and every fact. Did they know the person who really committed the crime? Who told them about it? Were they there as a witness but not a participant? So there's all these different possibilities that you know through interviewing your client about what they said and how each fact got in there. So going for the classic, they fed the facts to your client. You're going to have a lot of fun with that because you're, again, in one of these win-win situations. So detective, so we're back to the Dassey case. Detective, let me ask you this. Would you feed facts to a person that you're interrogating about a crime?
Of course not.
And is it fair to say that you have been trained to never do that?
That's correct.
But why is that? So let me just stop. I asked an open-ended question on cross, okay? Now, I don't normally go around doing this, and you can do this as a leading question. So like, my basic recommendation is do not do this unless you've been a trial lawyer forever like me and you're ancient. You know, in other words, when you ask an open-ended question, you've got to be completely prepared to deal with it. When you have a recording of what actually happened or actual training materials, you know that no matter what they say, you can take it and shove it up where the sun don't shine, and you're going to have a really good time. So it's totally fine to do this, but this is not normally how I cross. But in this case, I could lead, or I could just say, why don't you feed facts to people?
Well, you want to get the information from them. It's supposed to be their confession.
Okay. So let me ask you this. When you interrogated Brendan Dassey, did you feed him facts about what happened?
No.
You have holdback facts, things you're not supposed to tell, right?
Yeah, we keep these facts that we know about the case, and we use them to tell whether or not they had that inside information.
And important holdback facts, for example, like what the forensic pathologist or forensic anthropologist says about how somebody dies, that would be an example of a holdback fact, right?
Yeah, right, that would be something that only the person there would have known.
So of course you didn't tell that to Brendan Dassey.
Well, no. I mean, we knew that he knew it, but we didn't tell him.
No, you didn't tell him, of course, right?
Right.
Because that would be contaminating the interrogation. I mean, that would be feeding facts, and you can get false confessions, right?
Okay, yes.
Okay. Bam, I'm going to play that tape that I'm not going to make you guys suffer through. You know, I'm just going to come right out and say it, who shot her in the head. Now it's time.
But he knew before that. We knew he knew.
Detective,
we could tell he was behavioral analysis, you know. He was, the eyes were going up this way.
Detective, when I'm done with my cross, the prosecutor's going to get a chance to ask you questions. And if they think that this is important, I'm sure they'll ask you about it. Okay?
Yes, ma'am.
Thank you. Thank you very much. All right, I don't have any more questions for our little segments of live demonstration here, but obviously you're going to use the tapes, right? You're going to play the parts the prosecutor admits. It's going to be different than the direct exam. And you might be contrasting it with a written report because they have these written summaries that leaves all this shit out, and you want to have that in there. So, you know, Bridget showed us My Cousin Vinny, which is about eyewitness ID, but one thing I love about My Cousin Vinny is you can use it for any CLE, for any subject at any time, and that would also include interrogation. But why didn't it play? Oh my God. So, I'm really bummed out. So it didn't play, but as you guys know, the detective or the sheriff guy gets on the stand and he starts saying, I asked him, when did he shoot the clerk? And he told, or what, did he shoot the clerk? And he said he shot the clerk, right? So you remember that scene, and then, of course, there's the next scene, which probably also isn't going to play. So it's not going to play. And as you remember, you know, he's in there saying, when did you shoot the clerk? And he's like, I shot the clerk? I shot the clerk? So, you know, that's kind of what's happening in a lot of these cases. You've got to really look at how they're testifying and how they're writing reports compared to what really happened. So, you know, you've got to know about that kind of stuff, and you want to know it well, and you want to have that tape ready, which is why preparation, 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 okay? Really great cross-examination. It's not about being a freaking genius. It's about how hard you work to get ready and how you've got the goods, so when you cross-examine them, they can't win. And when you're done, one of the things that you can often do, I mean, it depends again on the facts of your case, is very often the investigation has ended after they've gotten the confession. You know, they're taught that they have these things called independent facts. And that part of are the holdback facts, like what we just talked about, that they're not supposed to tell. But then afterwards, they're supposed to go out and verify, is this confession really true? That they've got training materials saying that they should learn something new, or the Read people at least teach this, and they have it on their website. They should learn something new, and they can go out and verify something from the real perpetrator. But often that's not what happens. Often they get the confession and boom, it's done. They're moving on to the next case, right? So it's our investigators who are going and turning up the other facts that are really important to impeach their case. So, you know, it all works together. Our pretrial interviews, our motion hearings, our client interviews, our decision whether or not to put our clients on the stand, which is not the subject of what I'm talking about, but you know, we want to know, and what's so great about trial is anything can really happen in a trial.